All right, I'm gonna call the meeting to order then. I appreciate you guys being here. I don't know about you guys, I'm in Thomasville. It's a beautiful day down here in Thomasville. So I'm gonna go a little bit out of order. We're going, instead of asking Lazaro to go over the kind of the rules for today, I'm going to talk about some staffing changes. We've had some. I think all of you are aware of those. First is to introduce our new program coordinator, Lazaro. And Lazaro, are you where you can tell us a little bit about yourself? Instead of me just reading about you?
Of course. So I recently graduated from Morehouse last spring. I graduated as a political science major. I'm originally from Houston, Texas. And yeah, I started this job at the beginning of the month, and I'm very honored and privileged to be serving as the program coordinator, and I look forward to working with all of you. So thank you. Thank you.
And we're certainly honored to have a Morehouse man in the house. So it's very special. So we appreciate that. Second, and that's great news. Second is not so great news, at least for us as a commission, and that is that Noel has served as Assistant Division Director for AOC's Communications, Children, Families, and the Course Division since August of 2019. And though you may not know, I didn't know until recently, Michelle Barkley, who's the Division Director, will be retiring, and Noel will be moving up into that position. So it's wonderful for Noel. She'll kind of still be with us. It's a little higher up the ladder, I guess. We appreciate everything she has done for us, and we still have her till August 1st, 2025. And they will begin very soon to search for someone. I'm not going to say replace Noel, but succeed her. Noel, we appreciate your service.
Thank you so much, Judge Key. It's just been an absolute honor and privilege to serve in this role. We are going to start actively looking for my successor shortly. If anybody has any recommendations, we'd love to hear.
This is your chance.
Commission that it's great to have somebody in this role who comes from the private bar, and it's wonderful to have somebody in Kurt's position who's come up through DCSS. We think that's a really good balance. So we'd be looking for somebody on the private bar side.
And as I keep reminding myself, she's not leaving me. She's just going down the hall. She'll technically be my boss now, so looking forward to that.
Oh, I think that would be good.
Yeah, we've hit quorum. Judge Lisa Jones is here with us in person. So fantastic to see you. You're all the way up from Americas, right? Yeah, that's fantastic. And Judge Lamb joined online.
We're at one.
Right.
And I can't say, who did you, I'm sorry, there's a train coming by outside here. So who did you say just joined us in person? I can't tell.
Judge Lisa Jones.
Oh, Judge Jones, how are you doing?
Hey, good. How are you?
Good. So you went north and I came south. I'm down in Thomasville.
Oh, you are south.
Yeah. As Michelle Barkley used to say, South Georgia.
Yes.
So, and thank you for all of that. And now Lazaro, would you go over, let's see, the kind of rules of the meeting?
Yes, sir. So good morning, everyone. I am Lazaro Quintanilla. I am the program coordinator for the Georgia Child Support Commission. I will briefly discuss a few rules to help us navigate the meeting today via Zoom webinar. The Child Support Commission meeting members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. Also, anyone wishing to give public comment by speaking today may do so at the end of the meeting after the completion of our agenda. Please state you would like to give public comments by typing your request in the chat. Once you are called upon, we will unmute your audio. Our chair, Judge Key, will make the determination for how many minutes you are allowed to speak. In conclusion of today's meeting, staff will post this recording on our YouTube channel, Georgia Child Support Commission. We will place the YouTube channel in the chat for everyone. Thank you.
All right, thank you, sir. We now have a quorum according to my count.
Yes.
Right, so let's go ahead and address the minutes. The minutes were distributed. Everyone hopefully has had an opportunity to review them. Are there any corrections or additions to the minutes as submitted? The hearing none, then the minutes are hereby approved as distributed. I know we have, I'm going to go next on the agenda anyway is Dr. Totoro, so we'll go ahead and take his report. He'll need to be leaving us soon, so Dr. Totoro.
Well, thank you, Judge Keys, and reporting out for the Economic Study Subcommittee. 2025 will again be a year in which we have to begin our process again for conducting another study. And so we will get together, Chuck Clay and Jill Massey and I constitute the Economic Subcommittee at this time. And so we will caucus over the next couple of weeks and try to lay out a timeline. We likely will have some form of a public listening session for feedback, and then we will start going forward for the next round of the study.
Thank you, Dr. Totoro. Anyone have any questions or comments? Thank you. We'll move to the next item on the agenda, which is a report from the Statute Review Subcommittee. And either Katie or Judge Williford.
Hi there. I will do this for us. We had a statute review subcommittee meeting earlier this week. Thank you, Judge Key, for attending. Just briefly, and for the minutes of this meeting, the statute review committee covered and discussed issues like the 7% test, if you will, for deviations related to special expenses of child rearing, and whether such expenses, well, first of all, whether the 7% is a good number right now, supported by the underlying economic framework of our guidelines, how Georgia compares to other states in terms of using such a thing, what all is included in the definition of extracurricular activities for purposes of the economic studies that are, again, used for the framework for our guidelines generally, and then pivoting to whether the current treatment of that 7% test is appropriate in Georgia's child support guidelines. We had Dr. Jane Venor, the economist, with us to discuss that and some of the other issues. And the long and short of it is that the Statute Review Committee has is asking the commission for an opportunity to delve further into that issue and make recommendations, potentially make recommendations for changes to the legislative language related to special expenses of child rearing, not only in terms of the percentage, and amounts, potentially the definitions, as those seem to kind of change and get treated differently, which results in potentially disparate treatment in terms of our resulting child support orders. And we, in that discussion, we talked about some of the Georgia appellate law that has treated some of those things differently, and therefore also discussed possibly drafting some legislation to update our guidelines to remove that requirement from being in the child support calculator and making it a potentially an option to be handled outside of the worksheet, analogous to how we have the option to handle work-related childcare outside of the option, or outside of the worksheets or inside of the worksheets. So that was one point of discussion, and we would like the commission to essentially to authorize us to look into that further and even potentially propose legislative language on the subject. We had a similarly thorough discussion about appellate law, other states, and again, with Dr. Venor's input, related to Georgia's high income deviation and the possibility of getting some economic, some guidance from our economists on how we might pursue the high income deviation with more guidance for bench and bar. And again, are seeking the commission's permission to move forward with that, including potentially drafting some proposed legislation to address that issue. And last but not least, we also discussed the treatment of dental and vision insurance premiums in a way that is disparate from the treatment of medical insurance premiums, which sometimes results in an incorrect use of an incorrect shifting of those premium amounts from one parent to the other that is inconsistent with our economic shares, income shares model and the percentages therein. So it was a really robust conversation. I think it was productive. It was really helpful to have Dr. Venor there. And our subcommittee is asking for the commission to approve our further work on those 3 issues, again, including potentially drafting some proposed legislation to amend our guidelines. You're on mute, Judge Key.
Yeah, I was, you're saying 3, but they're 4 broken out as 4 on the agenda, but you're including all
Correct.
those. You wrote 2 together, right? So.
Right. It is 4 on the agenda, but the 7% test and the handling of special expenses of child rearing it's the same line item in our actual worksheets on Schedule E. So, I kind of lumped those 2 issues together because it is the same deviation in its application.
So, and this is a request from a standing committee, so I don't think it requires a motion in a second. So any questions or discussion on these points? Okay. All in favor, say aye. I can't hear all the ayes, so. All right, any nays? Anyone opposed? Any abstentions? All right, then go to work. Continue your work, actually. You've already begun work on it. We appreciate, I know the statute review subcommittee thought they were done when they worked so hard on these things last year and years before, but it's never done. So thank you. Thank you for continuing your work in that committee. You do great work. I know how hard it is because I chaired that committee for a while. All right, is there anything else we have to vote on? And just so Dr. Tuttle will know.
Katie, did you want to raise any other
Katie,
issues?
yeah, Katie, did you want to address the advisory memorandum that we talked about that Noel drafted?
Right. Yes, I did. I'm sorry. I'm sorry. I'm reading through my notes here and my head is in 5 places, including the brief I'm writing that's due today because, nothing like a lawyer to be a procrastinator. So we did touch base on this at the statute review committee subcommittee meeting. At the request of the subcommittee, Judge Williford and I had asked Noel and Kurt to look into our authority and sort of what parameters, if any, exist in terms of providing advisory opinions on the part of the commission. At the subcommittee meeting, Judge Key correctly and wisely pointed out that, just because we can doesn't mean we should. And those are 2 different questions. But our initial question was, can we? The should we, I would think, would be handled on a case-by-case basis anyway. I think it's fair to say, and I'm happy to have Noel give a more thorough update, but we do believe we have the authority to do that, and maybe even sort of a charge, because we are told to advise. So as a result of that, we've talked about a advisory opinion about the question or issue of whether the parenting time adjustment upon its mandatory effect on January 1st of 2026 would in itself justify a modification. In other words, would it meet the threshold requirements of a substantial change in circumstance warranting a modification? Of course, every case will have to be taken on a case-by-case basis, but could that in and of itself open the door, for example, if there were no other appreciable changes? And it is my opinion that we should issue an advisory opinion that we think it does open the door to that. But I realize I am just but one member of the commission. So Noel, do you want to speak a little more to that?
Sure. So there's nothing expressly granting a specific power that says literally advisory opinion, but there are certainly plenty of statutory duties that we have to study in general these issues, recommend legislation, etc. So there's no prohibition, and I think the commission would be within its mission to to issue an advisory opinion. I've never seen one done. To my knowledge, it's never been done in the history of the commission. It could possibly be opening a can of worms. I also have to say, if we do it for this statutory change, well, I think we need to be mindful and reflect on why would we do it for other statutory changes? We're basically calling out the, parenting time adjustment, potentially, and not raising up just the changing of the BCSO table and the low income adjustment too. So that's something just to be aware of.
I agree with Noelle. I think we should handle it cautiously and have conversation.
Is this an action item, Katie, as you said today? Or you asking that we take some action as a commission?
Well, I would ask that we at least discuss it.
I think if I may, the reason it came up was as an alternative to going to the legislature and reopening that can of worms, that we were so afraid that they would tack something else on to our bill or change our bill. But that question is going to come up a lot. It's going to come up with practitioners, it's going to come up with judges. Does these changes that are going to be in effect January 1st, does that amount to a substantial change in circumstances? And we didn't address that in the bill, and perhaps looking back, maybe we should have. So the question was whether or not, we were going to ask for the legislature to, make changes. And perhaps if we're going to do those things, if we're going to work on those other items, which I think desperately need to be worked on, regarding the 7% test and the high income deviation, the dental and vision insurance, and those other issues that the subcommittee is working on. If we're going to address those anyway, then perhaps we also address with the legislature potential changes to the statute that clarifies whether or not these changes amount to a substantial change of circumstances. But in the meantime, we were afraid that we were going to be, and in fact, I know that we're going to be, because I'm already starting to get those questions
Me too.
from practitioners who practice in front of me, whether or not, this is a substantial change in circumstances. And so we just posed to Noelle, would she mind looking at that issue and telling us, if an advisory opinion would be a temporary, if not permanent, but temporary solution. And, I don't know the answer to that. We just wanted, everybody's sort of buy-in or opinion on that issue. Whether or not an advisory opinion would be a good thing to do, and if we could do it. And B, whether or not these changes would amount to a substantial change of circumstances potentially in and of itself without having some other change.
And to echo Judge Williford there, I am being asked regularly by practitioners and judges if this, if the parenting time adjustment specifically will, and they're asking, just for context, they're asking, and essentially the question really is, so in cases where there was no parenting time deviation, but there is court ordered parenting time, will the fact that the parenting time adjustment is now going to be required, warrant a modification?
Which of course could just open the floodgates for litigation. And I think everybody on here, most everybody on here was around when this initial, income shared model came in, and that was the concern, is that all of a sudden there's going to be thousands and thousands of, cases filed to modify child support, and how we were going to deal with that. We've not really addressed that in the substantial changes that are coming into effect next year, including the parenting time adjustment.
Judge, if everybody else is finished, who's spoken on that, I just don't think it's our purview to issue an advisory memorandum or opinion on this matter. I don't want to be in the business as the commission of issuing those. We are, I think if we're concerned that somebody doesn't understand all the issues or the relevant case law to be applied in making their own analysis, we could certainly, I guess, I could support putting together an informational memo, collecting all of the case law and the authority so that someone else can draw their own conclusions, like a legislator or a judge. But I would be a hard no if that comes to a vote on getting in the business of advisory opinions.
Well,
Thank you,
thank you,
Regina.
Regina. Your opinion means a lot to me, and I'm sure to all of us.
I was going to, of course, I'd love the input from anybody. I don't want to stop the discussion just because when no vote kills it today, given that we have a bare quorum. Well, it doesn't kill it necessarily, but I was curious particularly about, we're the executive branch. I was curious from a legislative perspective and from a judicial perspective, kind of what Regina was talking about. You know, from a judicial standpoint, Judge Williford is with us from the Superior Court. You know, if we say that it does, if our opinion comes out and says that it does constitute a substantial change, you know, all the Superior Court judges are going to be mad at us probably because we're encouraging all this litigation. Is this really the purview of the legislature? You know, the question may have been, since it was silent on the issue, then what was the intent of the legislature? We had no legislative history. It was probably not discussed during the legislative process anyway. So does anyone else want to speak to this issue?
I would like to add, so I too consider Regina's opinion and hold it in the highest regard. And so much so that when I have questions about things, Regina will often find she gets a little text from Katie Connell saying, what do you know about this? Or what do you know about that? But it's not to say that I disagree with her, but maybe I do. I'm not sure. What I will say is my understanding is that our enabling statute 19653 states that one of the duties of the commission is to, quote, study the impact of having parenting time serve as a deviation to the presumptive amount of child support and to make recommendations concerning the utilization of the parenting time adjustment. So I think, you know, make recommendations concerning the utilization, you know, it is in there. So, you know, now, is it a matter of, you know, the nomenclature? It could be we're talking semantics here. Maybe we don't need to issue an advisory opinion. Maybe I'm not sure. I mean, I think in a way by having the parenting time calculator, parenting time adjustment tool on the commission's website right now, you know, which we voted to do, with my support. I mean, I think that is in a way it is an advisory opinion, even if we didn't title it an advisory opinion. I think we have, you know, I think we have provided some recommendations concerning that, and, you know, concerning the parenting time adjustment and the utilization of it. By virtue of that, I think some of our training videos have done that as well. So, you know, now am I wedded to the idea that we title something advisory opinion and throw it on the website? No. But do I think that it's within our purview to weigh in on this question? Yes. I also agree with Judge Williford's recitation of sort of the history of this that we had discussed, potentially even going back to the legislature and saying, hey, add a clarifying sentence to the code, and decided that that probably wasn't worth the effort and the potential downside to do that. you know, in answer to some of the comments earlier about, well, what about not doing it for the other changes, like the changes to the BCSO table? I think there's a big distinction there. You know, changing the BCSO table is, first of all, it's directly contingent on any changes in income. It's, you know, it's like, it would be like if our child support guidelines had a cost of living adjustment in them. I also think there's a big difference when we went from the percentage model to the income shares model, and we put in that, you know, that percentage difference cap so that we didn't have the flood of modifications. But again, we were not in the position with either one of those changes, the current change to the BCSO table we just did, and even when we switched from one whole scheme of calculating to another, neither one of those switches were based on the fact that our underlying economic model contemplated something that didn't get put in. What we've done with the parenting time adjustment is rectified the fact that we used an economic model that that didn't account for parenting time and should have, based on the way it was set up in the first place. I think that's a distinguishing factor. You know, and for example, it's even different than the low income that we also just changed and goes into effect January 1. You know, that our underlying economic model didn't contemplate that our underlying economic model is not in any way compromised by not using a low income deviation or adjustment. We have added the low income adjustment because we found that the low income deviation was underutilized, and therefore many parents were simply not paying their child support. We're not saying that our actual calculations and our economic justification for the dollar amounts that come out, even in those low income situations, are not supported. We're effectively, and anyway, I think y'all know what I mean, but I think it's a distinguishable thing in this situation. I also agree that it could increase the amount of litigation or modifications filed in the first of the year, which is one of the reasons that we've so heartily been encouraging the bench and bar to go ahead and start using the parenting time adjustment now. Let's reduce those. Anyway, I think this is a unique situation where we are looking to correct an economic wrong.
Well, two things. One is we've lost our quorum. Dr. Totaro told us in advance that he had another meeting he was trying to juggle. But also Judge Land has put in the chat a couple of very good questions, and thank you for that, Judge Land. Have we issued advisory opinions in the past? Would doing so be an unprecedented step for us? We have never done that in the past, and it would be an unprecedented step to do it. And kind of where I was on it, let me say first, any other comments from anyone?
I was just going to add, and some of that's fairly obvious, and I'll hush up, but certainly it was not discussed because I happened to be there. And of course, many of the ramifications were not thought of or discussed at time and place, which is certainly not unique, but this is a uniquely complex subject that has evolved over the years. We've got several legislators on there. I know in Houston, Gaines, a part of this group. I know they're in session this morning. I'm not down there. We would certainly want to ask, I mean, just as a matter of protocol, I would certainly advise, certainly I can't be a judge or whoever else on this committee should talk to Houston about that. I don't have a hard view on it. We don't have a quorum anyway. I'd be very wary of setting precedent. And some of it is, as was pointed out by Katie, is semantics. There are statements to be made, and there are broader pronouncements that have a quasi appearance of law, and I'm wary about that in courthouses. I'm not a domestic lawyer per se, but I would just be very wary. Even if there's an opinion to do so, I think we would want to scrutinize very closely both the semantics, the language, and how we want that to be viewed. But we certainly ought to include our legislators in this discussion before we kind of make any hard decision one way or another.
Thank you, Chuck. And I don't know, I'm asking the question because I don't know. Is this a question that would be appropriately addressed to the Attorney General's office for an opinion? Based on prior case law, legislative interpretation, those sorts of things?
Good point. Jordan Watson's a longtime friend over there. He's the policy guy. You all know him. Judge, you could pick up a telephone and just see if they have any interest or something they might have, either formally or informally, an opinion or a view on.
I mean, I would like to know the answer myself. There may very well be a legal answer based on prior case law to it. It's just a legal answer, no matter kind of what we say. There may be an answer. Ultimately, some judge will have the responsibility of deciding that. And then if it's important enough, somebody will take that up and the appellate courts will deal with it. I think that's part of what we're trying to avoid to some extent. And if there is a clear answer based on precedent to it, I think that would be very beneficial. Whether that's done by Attorney General's office or by someone with a state bar and family law division, or someone on this commission that wants to put the time into it to do the research and write sort of a brief, kind of like what Katie's working on today, but a real one. So I think obviously it's not an action item today because we've lost our quorum, but where I was leaning, and Chuck said it very well, is that this is such an important matter that we should not decide it based on a bare quorum, even if we still had a quorum. And certainly since that specific item was not on the agenda. So depending on how time sensitive we think it is, then we should put it on the next meeting agenda. The issue of whether we are going to be in the business of issuing advisory opinions, or if it's more time sensitive than that, then we can call a meeting, set up a meeting for that limited item on the agenda in the near future after legislative session, of course, because we do need our legislators here. We can draw from.
Judge, will you call, I mean, I don't mind, I'm not really the person to do it, but I do see him all the time. Houston's one of the more thoughtful, smart and hardworking legislators down there. That's not me pumping him for reelection, though I would anyway, but he is a very thoughtful, hardworking guy. Somebody reach out to him maybe before this next discussion. I'd love to have his kind of, again, off the record or on the record sort of input.
Judge Wilford?
Judge Key, if I might, it's really a broader issue, I think, in that the question really in my mind is, what should the commission do regarding whether or this issue of whether or not the parenting time adjustment is a substantial change in circumstances standing alone that would warrant a hearing on a modification or an ability to file and be heard on that. And so the options are, advisory opinion or advisory memorandum, or, as Regina said, maybe a memorandum of these are the areas that you need to look at to make that determination, perhaps, or changes to the statute, the legislature addressing that, what are the options? So for me personally, I won't speak for the entire subcommittee, but the advisory opinion was sort of one of the options that was thrown out there. Would this be an option? And Noel, would you mind looking at whether or not this could even be on the list of options? Not necessarily that the subcommittee is saying this is what we should do. We should issue an advisory opinion, but this is the issue. We need to figure out which one of these ways is the best way, either temporarily or permanently, to answer this question when we're getting these questions, which we're already getting, about whether or not this, amounts to a substantial change of circumstances warranting a modification. And so the broader question is, which one of these things should we do? Can advisory opinion even be on the list of options? And if it can, should it be? Is really where we are. And the fear was that we were going to open up, I guess I'm personally terrified of the legislature because I've seen them tack things onto bills that didn't even belong in the bill and all these sorts of things that happen. So I've been terrified after all the work that we've put into these changes and that passed, and we were so excited about it, that something would happen to that, but maybe we shouldn't live in that fear, because there are going to be other changes that need to be addressed. And maybe we shouldn't live in that fear. Maybe that's the best option, because frankly, as someone who practiced family law for many, many years, I looked to the statute. I didn't search for advisory opinions, so even if advisory opinion was out there, I'm probably, and maybe I would have never seen it, because I'm going to look, to the statute. But that was really the question. And I agree that other people need to be involved in this, and other questions need to be asked and discussed with other people. But it wasn't that we were just trying to hard sell an advisory opinion. It was really, was that one of the potential ways that we could educate people, and didn't know the answer to that, and asked Noelle to maybe see if she could advise the subcommittee on whether or not that was one of the options.
You're muted again, Judge Key.
When they start dumping ice in the bins and things, I have to go to mute. So, yeah, Noelle, you have your hand raised?
Yes, I just want to chime in with, I absolutely do think the best and safest course here would be to propose legislation. That is one of our express duties. And so that's the safest. It certainly is also the most complicated. And it's important to know that, yeah, we research and make our best recommendations to the General Assembly, but then it's up to them to modify the statute. So it could be seen as an end run around that process. Also, as I started off earlier saying, we don't have any express duty to do this. There's certainly no prohibition. I think it's a gray area, but given our mission, I think we would be, it's possible to do, but I absolutely think the best and safest method would be to propose legislation. Now, that would be, if it went through and was passed next session and went into effect during a normal effective date of 7/1/2026, we would have about 6 months of gray area.
That would be worst case scenario, I would just say, because certainly it could be passed and effective upon the governor's signature. So that would be worst case scenario, is that there is a delayed effective date.
I know one concern that we had, and Judge Wilbur talked about that, certainly this legislative session, before it goes into effect, then there might have been changes to it and might have been undermined totally what we were trying to do. That can't happen now. Not enough time left in the session for that to happen. And you're right, Regina, never say never, but it would be unlikely with all the other things on the plate of our legislature now that anyone would have an appetite for diving into this, since both chambers would have to deal with it. But so maybe, and then it would be in effect when the legislature starts next time, but probably not enough time to generate a lot of public thought about it one way or the other. So
it may be much to do about nothing, so maybe, and you're right. I think when we first started talking about this, we were concerned about this legislative session. I'm no longer concerned about this legislative session. So that helps a lot. So it may be that the best case scenario is for the subcommittee to talk about these other things that we think are very important, that need some legislative changes, to work hard on that, and to include this issue in that, so that we can be ramped up to discuss all of these things with the legislature next year.
And Chuck, you and Regina can probably answer this question because you've both been in the legislature. But just a couple of legislative councils back, we had someone who did such a great job advising us for years on legislative matters and interpretation. I mean, she was an expert on legislative construction, all those kinds of things. Those people are still around. So two avenues that I see as to this and other things. One would be whether the Attorney General's office believes it's something they could render an opinion on. The other would be to get one of our experts among legislative council, get one of our legislators to request that they do an interpretation. It may be easier than we think. There may be an answer we don't even know about as to this issue. And there may be case law already. There probably is some case law, if not in this area of the law, in some area of the law, dealing with this. So I would look to those places first, probably. The Attorney General's office, the legislative council, someone's an expert on construing legislation. And then,
We just have to, you have to have a legislator ask for it, but that's very easily done.
yeah.
And Judge, legislative
yeah.
council is on the call with us today. It's Holly Parker.
Yeah.
Oh,
Oh, yeah. So, yeah, so I think that would be a great thing to do from legislative council. I don't know which would carry the most weight, an AG's opinion or legislative council's opinion.
I want to clarify, Judge Key, that you would be asking them to speak on whether the commission has the ability to issue advisory opinions
No, I'm speaking to issue an advisory opinion on this issue.
on this.
Whether or not, if you construe the statute and considering case law, whether or not this would constitute substantial, would have retroactive effect. Just the fact that the bill became law would be a substantial change of condition sufficient to justify the court jurisdiction to consider a modification of child support. That issue.
If I could just interject quickly, our constitutional opinion or the issue that we would be taking up would just be the statutory and constitutional interpretation. It would not be any sort of, obviously, any sort of policy consideration. It would just be the strict legal statutory interpretation of a policy or a statute. Thank you.
Yeah, and that's what I'm asking for. Yes. Not any broader issue, just that, because there may be, like I said, there may be an answer already on this issue that brought the subject up now. Yeah. But we'd have to have a legislator make that request. Right?
Not necessarily, sir. It's just with session right now. That's something I could totally take up and look into. It would just take me a little bit of time, but I will make it as much of a priority as I can at this time.
Thank you, Holly. And I understand session's in. So
only 2 more weeks. So after that, I'll have far more time to devote to such research and things.
And maybe a special session. I don't know, depends on the tort bill. So I think that's gonna be handled. But if you would do that, Holly, that would be great. Just when you can. This is not the biggest priority for you. I understand that right now. So thank you for doing that then.
Certainly.
I think we do need probably at some point to address this larger issue of whether we need to be in the business of issuing advisory opinions. Just one concern I have. So we have a really big issue and we have a lot of disagreement among the group on whatever that issue might be. And we have an 8-7 vote and, I don't know, it's just something, doesn't seem like something that we might could do more harm than good down the road, but we can't do anything on that today anyway. Holly's agreed to help us out on the immediate issue. And I would ask, what's the pleasure of the group on the advisory opinion issue? Is that something that we want to put on our next regularly scheduled commission meeting, or would you like for us to give notice of that specific issue and have a meeting for that purpose in the near future?
Put it on the next meeting.
Next meeting, everybody okay with that?
Oh, I think it would be fine to put it on there so we don't lose track of it if we want to look at that issue overall. I'm less and less convinced that we should be doing advisory opinions, but that's just, being easily persuaded this morning by all of you who I admire so much. But in the future, if it were to ever come up again, it'd be nice if we just had that answer. So I would like to not lose track of that issue.
And you always hate to make big policy changes around a single issue.
Right.
So let's, if we can we put that on the next regularly scheduled commission meeting?
Yes, we
Will
will.
do.
I've got to get my agenda back up. I'm operating off two computers here. I don't have a hard copy of the agendas.
One ahead of me, two ahead of me.
We're on Technology and Calculator Subcommittee. Regina Quick.
Yeah. Regina, thank you, Judge. Wilson.
Thank you. Just very briefly, the subcommittee last met on October the 18th. And discussed the calculator modernization project. That does continue to move forward, although not on the timeline that was discussed at the last commission meeting. So commission staff has been busy testing the new calculator, and the IT team has been involved in that migration portion of the project, migrating the current calculator worksheets to the new calculator. And rather than me trying to interpret anything technology oriented, I'm pleased that today we have Christy King with us, who is the IT project lead for the calculator, to provide you all with details on the data migration, perhaps a new timeline, and to discuss fully the launch of the new calculator and answer any questions that might arise. So Christy, I think you're on here. I saw you earlier. You can go ahead with your report.
Sure. Thank you for having me. I'm happy to give you guys an update on the calculator project. So we are in the final phases of this development. We are now focused on the migration of the data from your current system into the new version, which is over 600,000 historic worksheets with more than 1 million rows of data that we're moving from 2016 into the new application. So with that, we're obviously taking extra care to ensure that the data is accurate and that the integrity of the data once we move it remains as well. Quality assurance at this point is our top priority, and we want to ensure that this migration meets our standards, but also your standards and what you expect in terms of the data. So once that's complete over the next few weeks, that migration, we're going to ask the commission team again to do another round of intensive testing, ensuring that all of that data that we migrated is functioning and displaying as expected, and that we are free of bugs. And then with that, we'll move towards our production plan. We have taken a few extra weeks on this migration, really to ensure that it's done properly. We are within budget and getting back on track in terms of time frame. So we are looking forward to a successful launch in the next month. That's our goal and our timeline right now. So I'm happy to answer any questions that anyone might have, but our focus right now is the data migration.
Any questions for Christy or Regina? Well, thank you for that, your hard work on that. We appreciate it very much.
Thank you.
Subcommittee assignments. We agreed at our last commission meeting to take another look at our assignments, find out who's still interested in serving on the committees, and any additional new members that we have. And I think that was a very successful process. I think we have some good working committees now. Is there any comment or questions around that? Yeah, I appreciate the staff's work on making that happen as well. The next on the agenda, thank you for Judge Willard for propping me up when I lost my minutes over there. You're a great vice chair, so already. Update on uniform Superior Court rules 24.11 and 24.12. Noel?
Yes, if I could just, before I address that, Kurt had wanted to mention something about the subcommittees.
Yes, I do want to report that Pat Bonadono is no longer on the statute review subcommittee. She contacted me earlier this week and had to resign for personal reasons, but she's no longer on there. We may have another member joining the statute or the technology and calculator subcommittee though, so keeping track of it.
And as to the Uniform Superior Court rules, I have good news. It passed the Superior Court Judges Council for a second time in January. I spoke with Shannon Mothers, your executive director, just late yesterday. And he said it's going through its normal process. It's under a formatting review now, and then it'll go off to the Supreme Court for their final review. But he anticipates everything should go smoothly and this should be wrapped up within the next, certainly within the next 2 months. I'll just remind everybody that was basically a terminology change to make sure that the Uniform Superior Court rules match the changes in the statutes about IDOs and now IWOs and holding orders. And that legislation was to make sure that the state statutes matched federal regulation and terminology. So that's all going smoothly.
Any questions for Noel about that? The next item on the agenda is new business. At the commission's last meeting in November, we discussed the issue of child support and juvenile court dependency cases and how the issue was raised to the commission. One of our guests, Diane Kelly of the Children's Bureau Region 4, spoke to a new policy on this issue, published by DFACS, updated by DFACS, noted that new policy supports the reduction of referrals to child support for children in the foster care system. Regina advised that DCSS has also updated their corresponding policy. Judge Neil Brunt, President of the Council of Juvenile Court Judges, spoke on the topic as well. I'd ask the commission staff to share with Judge Brunt those policies from DFACS and DCSS and requested Judge Brunt to share the policies to the Dependency Committee of CJCJ. I was at that committee meeting, and ultimately CJCJ's chose not to render any opinion on the issue due to what they consider to be ethical concerns, but weighing in on it. Are there any questions about that? I mean, to me, there's some larger issues around child support and dependency cases that I would like for us to address. But I would like for that request to come from the council again. So I'll try to make another run there. Again, as DFACS has done, in my view, an exceptional job of promoting family preservation, keeping families together, sometimes on voluntary family preservation, sometimes on court-ordered family preservation, then it helps oftentimes when we're expecting, say, the mom to maintain safe and stable housing, to create a revenue stream for her and make it easier to do, you know, and really almost immediately in the case, and find a way that income stream can be sustained when the court gives up jurisdiction, rather than have to go through the process of getting into Superior Court. And so I would talk again to the Dependency Committee of the Council and see if they can make a request to the Commission to look at that issue. If anybody has any questions about that, I'll be glad to answer them. I think it is an important issue for us. All right. Have we had anyone sign up for a public comment?
We actually have somebody in person with us, Judge Key, but I don't see anybody on Zoom.
All right. Let's see, we have a good bit of time. So how many people have signed up?
Just one.
One? Okay. All right. Then let's give whoever it is to come up wherever we need for that person to be seen and heard. And I will give say 10 minutes, no more than 10 minutes.
So I listened into the subcommittee meeting on Tuesday, and it was then that I learned that my case is a pretty infamous case in the Court of Appeals. My case is Tubbs versus Cousin, and I am Adrienne Tubbs. And so I've written out my speech, and kind of lengthy, but so I may not be able to get through all of it depending on how much time I'm allotted, but I'd like to read it. So, hello, esteemed committee members. My name is Adrienne Tubbs. I come before you today as both a concerned citizen and a mother of a 13-year-old boy who has fought tirelessly for my child's right to financial support. I appreciate this opportunity to speak. I sincerely hope that my words today will inspire meaningful change in Georgia's child support enforcement system. I want to bring your attention to the specific lack of specificity in Georgia's child support statutes. These ambiguities have made it far too easy for non-custodial parents to repeatedly evade their financial responsibility. There is a desperate need for a clear and concise hierarchy of consequences for those who repeatedly violate child support orders. It is simply not sustainable, nor is it fair for a parent to repeatedly neglect their obligations. Yet these same offenders often face little to no meaningful repercussions. In this current economic climate, custodial parents cannot continue shouldering the financial burden alone, while the legal system gives negligent parents an endless number of chances to display their same harmful and alarming behaviors. This pattern of leniency is one that I know all too well. My initial child support order was entered in 2012. I then filed for modification in 2017, which was ruled on in 2018 in Paulding County. Since that time, I've had to return to court for contempt and compliance hearings in Paulding County many times. Additionally, I became aware of the possibility to file for child abandonment in 2023. In the past 2 years, but I've had to take my son's father to child abandonment court in Fulton County well over 10 times. It has reached the point where the court staff and even the judges in multiple counties recognize me the moment I approach the podium. That alone speaks volumes to how broken the system is. No parent should have to become a regular fixture in the courtroom just to secure financial support for their child. The fact that I've had to fight for nearly every dollar of child support since my modification order and was entered in 2018 is unacceptable. The inconsistencies in how these cases are handled has only added to my frustration. In magistrate court, when the child abandonment cases are heard, judges have often expressed uncertainty about whether they should base their judgment on the 30-day period that initially prompted the warrant application or consider the time between the application and the hearing date. Scheduling of the hearing can sometimes take another 30 to 90 days. The statute should be clear because the last person in the courtroom who should be confused is the judge. When there's a lack of clarity in the law, the children suffer. Even after my son's father was caught red-handed attempting to deceive the court about his finances, address, etc., he continues to receive leniency. After years of fighting the same battle, my son's father was finally incarcerated in Fulton County for a few short hours for his willful neglect of our child in October 2024. I feel it is my duty to highlight the need for stricter enforcement in child abandonment cases. In cases where probable cause is found, the hearing should not be an opportunity to make a last-minute payment for repeat offenders. Hearings in such cases should be about imposing consequences. A non-custodial parent knows well before the hearing that they owe child support. They should not be allowed to escape punishment by making a same-day payment in court. It is disheartening to see the same faces in child abandonment court over and over because the current system does not deter non-payment. There must be a structured, tiered system of penalties for repeat offenders. After a judge finds probable cause for contempt or child abandonment, the punishment should escalate based on the number of prior offenses. A non-custodial parent such as my son's father with 10+ contempt and child abandonment findings should not be walking free after just a few short hours of jail time upon making a last-minute payment. This is not an adequate deterrent. There needs to be a firm statutory limit on grace periods and a tiered system for jail time, license suspension, etc. The system is failing children like mine because it does not provide real accountability for repeat offenders, sorry. While I have a great deal of respect for the judges presiding over my civil cases, I must emphasize that when dealing with a child's well-being, there is little room for leniency or niceness. Year after year, my son's father repeatedly demonstrated that he has no regard for the orders of the court. Nonetheless, every single time he is found in contempt, he is granted an extended grace period to satisfy his arrears balance. These grace periods for him to pay when he already knows that he owes are typically a minimum of 20 to 60 days post the hearing date. While grace periods and opportunities to make payments are reasonable in some cases, they should not be endlessly extended to individuals who have demonstrated a consistent disregard for their legal and financial obligations to their children. After a 13-year battle, my son's father's driver's license has finally been ordered to be suspended despite years of repeated offenses. Additionally, the very first Paulding County warrant for his arrest was finally issued just a week ago, on March 11, 2025, or maybe 2 weeks. Despite years of the same cyclical, blatant disregard for the court's authority. Why did it take this long? The delayed justice only emboldens non-compliant parents to continue their misconduct without fear of real consequences. In December 2023, a Floyd order was issued in my case in Paulding County Superior Court. The order was meant to issue an automatic arrest warrant for my son's father's failure to pay his child support by a specified date and time each month. However, because my DCSS case is considered receivable only, the Floyd order was not enforceable. The child support office advised me to request the judge to amend the payment address to the Paulding County Sheriff's Department versus their office to enable enforcement. I have filed several motions requesting that change, yet I got denied. How is it possible that a Floyd order, a measure specifically designed to hold habitual offenders accountable, is ineffective in one of the most deserving cases? This is an example of why statewide standardized enforcement mechanisms that leave no room for judicial discretion to override the well-being of children. And this is the last page, guys, if you guys are wondering how long this is gonna be. Beyond legal clarity, we need a well-defined enforceable hierarchy of consequences for non-custodial parents who repeatedly fail to meet their obligations. As it is presently, judges have too much discretion in deciding these matters, while it is the children who suffer. Unfortunately, and not likely to be with malicious intent, judges do not always make decisions that are truly in the child's best interest. If the roles were reversed and I, as the custodial parent, failed to provide for my child, I would not be granted as many chances. I have regrettably seen my child's father and others like him receive too many opportunities to evade their responsibility. My son's father has testified to making millions of dollars per year, yet he still manipulates the system, attempts to hide assets, and dodges his financial responsibilities, and still he is given grace. In addition, I propose that employers be required to report the presence of non-custodial parents who have active arrest warrants for non-payment. Another reform to consider is preventing individuals in arrears from renewing their vehicle registration each year. The ability to drive is often a necessity, and linking compliance to car tag renewals can provide additional enforcement leverage. It is unacceptable that parents who have means, like my son's father, can manipulate the system, hide assets, and still face no substantial consequences. If the laws were applied as strictly to non-custodial parents as they are to custodial parents, we will begin to bask in the glory of overall justice. Currently, my son's father has 2 active arrest warrants, one in Fulton County for failing to appear for arraignment and plea hearing for child abandonment, and another in Paulding County for contempt of court. It has taken years of my legal counsel and I putting up a relentless fight to get to this point. Despite this, he remains free and able to continue dodging his responsibilities. I have brought copies of my speech for each committee member today who's in attendance. I urge you to review it carefully. I also welcome you to familiarize yourself with my cases for a single child throughout multiple counties, Cobb, Cherokee, Paulding, and Fulton. Should you take the time to research my extensive legal battle, I pray that you too are deeply disappointed at the struggle I've had to endure to seek justice for my child. Our children cannot afford to wait any longer. The time for reform is now. This is not a system that prioritizes children. This is not a system that routinely ensures justice. And this is not a system that firmly holds non-custodial parents accountable. Enough is enough. Our children deserve better. I urge that this committee take action to ensure that child support enforcement in Georgia is no longer a suggestion, but a firm and clear obligation. We need unbending consequences for those who repeatedly refuse to comply. Thank you. And that is all that I have.
Thank you for your comments. We do take public comment very seriously. I appreciate you leaving a copy of your notes with staff. For those of us not there, in fact, for all of our commission members, then since you want us to have it, I'll ask staff to send that out to all commission members. So that everyone in person, everyone here today, and those who cannot attend today will have your comments. I would also ask staff to review your comments and consider whether or not there are any specific action items within those comments that falls within our purview and our responsibility. And if so, we will find a way to address those either by assignment to one of our committees or to the full commission. Any other commission members have any comments, or staff members have any comments about that? I believe our next agenda item is just setting our next meeting. Do we want to do that today? Or let me ask first from staff or commission members, what would be the time of our next meeting? Is there a need to have a meeting in the near term?
Not that
Not to my knowledge.
Yeah, typically we have one in late August, but that's certainly up to you, Judge Key.
If that's okay with everyone else, that's fine with me. I don't see a need for one before then. And perhaps you want to try to set that date today, or how do you want to handle that, Kurt and Noel?
Well, we have 5 Fridays in August. One of those rare 5 Friday months. So we can do it on the 1st, or we could do it on the 29th, or any time in between.
I just asked if I could that we avoid a full judicial council meeting. That's typically in August. And so that's Friday, August 15th, but other than that.
Also, Friday, the 29th is the start of Labor Day weekend. So for purposes of attendance, I suggest we don't do it the first day of Labor Day weekend.
So, and I'm sure we all have different schedules. On August 1st and the 8th, I already have commitments. So it kind of narrows it down to the 15th to the 22nd. We can land on one of those dates today or send out a doodle poll for those 2 dates to the full commission.
I would actually ask that we, for staffing reasons, avoid the 15th. I think we're down to the 22nd if we want a Friday.
Sounds like the 22nd then. Of those members present, is there a reason you cannot attend on the 22nd that you know of now? I know that's a lot of months out.
I have a criminal jury trial, murder trial scheduled that week, but it starts on Monday. It may be finished on Friday and it may not, but that's probably going to be the case for any date that you would throw out there. So I certainly wouldn't, just to let you know, I may or may not be here.
Now, I've been in a similar situation August 1st that I am today, but I can make that work. I'll be doing the same program we're doing in Thomasville and Muskogee County that week. So if the first works better for everyone, as we sit here today, again, that's a long way out for court calendars and all sorts of other things. But if the first works better for everyone, we can shoot for the first. So everybody okay with that?
Yep.
Let's do that, because I certainly want those members who could make it today. We want to make sure they can make it in August. This is kind of our core group here in making a quorum. So August 1st, then 10 o'clock. Right. From 10 we anticipate 12, okay? Anything else we need to talk about? I appreciate everything staff did to get us here and everything they've done during this meeting. Also appreciate Holly being with us today. And of course, all of our loyal commission members for making it here today. We appreciate it very much. And with that, we stand adjourned.